people, because there's not enough room over there on that back row.
Okay.
And separate them. Have y'all got enough room over on this side? You good? Look like the benches are kind of starting to expand a little bit. All right, so. Well, are we ready to proceed? We got everybody here? All right. Bring the jury in.
Yes, sir.
Yeah, one thing, you can keep your seat for a minute. One thing, please let me remind you about, I do not know what the verdict is, and we won't know until the jury foreperson starts reading it. Whatever the verdict is, you must remain silent. If you don't think you can deal with the verdict or whatever it may be, I'm going to ask you to step out right at this point in time. These people have given a lot of their time and energy and attention and patience for 2 weeks now. Tell them, hold on. For 2 weeks now, and they absolutely deserve the respect that they're entitled to, whatever that verdict may be, because they have worked hard, and I don't want them to be placed in a position of feeling uncomfortable because either side might disagree with the verdict. I don't know what it is, but please refrain from any outward emotions until the verdict is read and the jury sent back out, and then you can more freely express yourself. All right, bring them in.
They're lining up in the hallway now. Here they come.
Be seated, please. Madam Foreperson, I have been advised that the jury has reached a verdict in this case.
We have. Yeah.
Has the jury reached a verdict as to each of the 16 counts?
Yes.
And was each of those 16 counts a unanimous verdict?
Yes.
And did you memorialize each of those verdicts by filling out the verdict form that was provided?
Yes.
And did you sign each of the individual verdicts as the foreperson for the jury?
I did.
All right, in that case, Madam Foreperson, if you would please stand. Mr. Reinking, if you would please stand. If you would just read the verdict of the jury.
In the criminal court of Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Reinking, case number 2019-A-55, jury verdict form. Count 1, we, the jury, unanimously find Travis J. Reinking for the offense of premeditated first-degree murder, guilty. Count 2, we, the jury, unanimously find Travis J. Reinking for the offense of premeditated first-degree murder, guilty. Count 3, we, the jury, unanimously find Travis J. Reinking for the offense of premeditated first-degree murder, guilty. Count 4, we the jury unanimously find Travis J. Reinking for the offense of premeditated first-degree murder, guilty. We the jury, count 5, we the jury unanimously find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder with serious bodily injury, guilty. Count 6, we the jury unanimously find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony, guilty. Count 7, we the jury unanimously find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder with serious bodily injury, guilty. Count 8, we the jury unanimously find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony, guilty. Count 9, we the jury unanimously find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder, guilty. Count 10, we the jury unanimously find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony, guilty. Count 11, we the jury unanimously find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder, guilty. Count 12, we the jury unanimously find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony, guilty. Count 13, we the jury unanimously find Travis J. Reinking for the offense of first-degree felony murder, guilty. Count 14, we the jury unanimously find Travis J. Reinking for the offense of first-degree felony murder, guilty. Count 15, we the jury unanimously find Travis J. Reinking for the offense of first-degree felony murder, guilty. Count 16, we the jury unanimously find Travis J. Reinking for the offense of first-degree felony murder, guilty.
And you may be seated. You may be seated. Is there anything else from the state?
Not at this point.
No, I understand that. Anything from the defense at this point?
No, Your Honor.
All right. All right, members of the jury, having found Mr. Reinking guilty of 8 counts of first-degree murder, of course, counts 1 and 13 will merge, 2 and 14 will merge, 3 and 15 will merge, and 4 and 16 will merge into one conviction, or for one punishment, let me put it that way. And since you have found him guilty of first-degree murder, we will be required to have a sentencing hearing. We're going to send you back to the hotel tonight. We're going to start the sentencing hearing at 9 o'clock. Okay, give them a few extra minutes to relax tonight. And the rules, overall rules, are a little bit relaxed tonight. You can breathe a little bit deeper and hopefully sit back and relax. And we'll get started at 9 o'clock. Please quit talking about the case at this point in time. We do have another phase. You're going to have a chance to, I'm sure you've talked about it significantly already. I don't even know if you want to talk about it anymore tonight, but don't talk about it anymore tonight. Try and put it out of your head and get refreshed and come back here tomorrow open-minded and ready to listen to the next phase of the trial as it relates to whether or not Mr. Reinking should be sentenced to life with or without parole. And there'll be different, it's the same type of procedure, but the evidence and what both sides will be presenting will be somewhat different than what's been going on so far. So just go back and enjoy your evening, relax, and we'll start back up at 9 o'clock in the morning.
All right, ladies and gentlemen, this way, please.
All right. Anything else for tonight? Well, we got some things we need to talk about, but anything else up to this point in time as to what the jury has done? All right, have a seat, and we'll kind of plan out how we're going to proceed tomorrow. I guess one of the issues is, do we charge the law as it existed in 2018, or do we charge the law as it now exists for sentencing purposes?
Judge, Mr. Bruno and I saw that, looked at it a little bit. The state's position that the 2018 law would, in essence, be more favorable, and it's required to be whichever law is most favorable.
That's the way I read it, because under the 18 law, it's parole after 25 years.
Oh, I'm not talking about that. No, we're talking about the,
Well, you don't want to weigh the factors.
correct. Actually, under the law now, the jury could impose a sentence of life without parole without finding an aggravating circumstance, and I don't think they would want that.
Right. The old law, you had to find one in an aggravating factor.
But Your Honor, the requirement about how much time, that has been 51 years for many, many years, even though the pattern jury instruction and the statute.
The statute says 25. That's what I was going to ask y'all about.
But
because it's always been 51.
It's always been 51, and that's been charged, and in the pattern instruction, there's a notation or a footnote that says statute hasn't been amended, however, a court should charge 51, and so I believe that's the appropriate.
Yeah, I agree, but I was going to ask if there was an issue about the statute. I think the law's been clear since the 89 Act was put into effect, but for some reason they put 25 in there. I don't know why. So we're going to go with the 18?
Yes, sir.
All right, I will, I've kind of redid it thinking the 18 would be the applicable one. I'll send that back out to you. I've got a few things to add to the basic required instructions by statute. Some of the general instructions and some of the concluding instructions and things like that, and the prefatory instructions, just to, and credibility of witnesses I put back in there. So just a few things like that. Anything else?
I can say for whatever planning purposes, based on the aggravating circumstances the state has alleged, we will be relying upon facts previously introduced and no new factual evidence, and assuming the court finds, as it's required to, that the state has proven an aggravating circumstance, then we would proceed with victim impact testimony. And those two aggravating
I think those are kind of
have been, by the jury's verdict, resolved.
absolutely. I mean, those findings have been made.
Yes, sir. Thank you.
How long do you think your presentation will be?
So we have 4 families, and,
At least.
well, no.
Well, that's right, because you're
No, we're
dealing with
limited
just the
to-
homicides.
Yes, Your Honor, to the homicide victims' families. In this hearing, we've explained that in
There's
the
another
other
hearing.
sentencing hearing, all the others, and actually the victim's family could come back and testify to that as well. But I would think 2 hours, two and a half at most.
Okay. No, I'm just trying to plan their day
No,
tomorrow.
that's why I said, as far as no additional factual proof.
Yeah. Well, the court already finds the aggravating factors have been established. I mean, there's no dispute about that.
And the only other thing is, under State v. Nesbitt, which was a death penalty case, the courts are required to have victim impact testimony screened. In other words, a dry run. In matters that I've had since then, the parties have agreed that since it is not a death penalty case, that screening is not necessary. In other words, we don't have to have them testify out in the presence of the jury and then rule on it. So that's
Is
what
that
the
correct?
state would ask is that they
We don't need a dry run.
All right.
Thank you, but that is,
Anything else from the defense? You know how long yours might take?
Not very long. We may have one witness. I've got 2 documents I want to enter. Hopefully I can get an agreement to enter those without having to call 2 witnesses to authenticate them.
I'm sure the state will cooperate. All right, so this could be submitted to them maybe by lunch, because the charge isn't nearly as long as, I know everybody's disappointed, but it's not gonna be as long as my earlier charge.
I think that sounds about right.
especially the court reporter.
All right, anything else for tonight?
No, Your Honor.
All right, y'all have a good evening, and we'll see you back here. We'll start at 9 o'clock. Give you an extra 30 minutes to lay awake. Yeah, that's true. And there won't be any eyes.
This was. If they want.
Yeah, I'm good. Go ahead.